All right. Good morning, everybody. My name is Patrick Fife. I'm LIBOR's general counsel. Thank you for being here this morning. Welcome to the legal update. So I just want to spend about 2 minutes just letting you know where you can get some resources to stay on top of the ever-changing legal landscape that you all have to deal with regularly. I've if you've taken a class with me before, you've heard me say, taking your 1 hour legal update every 2 years really is not enough to stay aware of all the changes that are constantly happening in this industry. I heard a good quote this morning on a podcast. It's do a little, a lot, right? So you need to find a way to do a little, a lot in terms of staying on top of changes. Getting, a little bit of information regularly is a lot better than taking just one course every 2 hours, every 2 years, or trying to kind of take the fire hose of information, all at once. If you just do a little bit every week, you'll really be ahead of the game. So how do you do that? I can't stress enough the importance. Make sure you're getting LIBOR's emails. That Thursday email that we send every week has a legal tip in it, has links to the website that have a lot of the important information, not only from LIBOR, but also things from OneKey, customer service tips, making sure you're familiar with all the OneKey rules. Please make sure you're getting that. Take a look at it. If you're a broker or you're an office manager, make sure you're getting our monthly newsletter. There's a broker portal on the website just for brokers and office managers. Has a lot of good information for you to push out to the agents in your office, so that you can make them aware of the changes that are happening. Helps you keep up with your obligations of supervision. All the different events we have. A lot of them are free, a lot of webinars. Sign up for those things. It's really valuable information that's going to keep you compliant and make you better at your business. Please take a look at our website, lirealtor.com. A lot of great information in terms of the legal tips that are out there, our forms, documents on demand, our dispute resolution center. It's something I want to stress to everybody. I know you're all familiar with our code of ethics, our arbitration manual here. And that's where you can go to file an ethics complaint. That's where you can go to file an arbitration request if you're a broker. But we also have a great ombudsman service. It's a free service available to our members. If you're having a communication breakdown with another broker, another agent, you want to avoid getting into a dispute, into a litigation, into an ethics complaint, an arbitration, give a call to our professional standards department. We may be able to assign an ombudsman, which is a neutral third party, very knowledgeable realtor who can help facilitate a discussion and possibly break through and avoid whatever, and overcome whatever issue you have. It's a free service. We a very high success rate, 80 to 90% of the calls that we get where we bring an ombudsman in, they resolve the issue. So it's a really great service that's part of your LIBOR membership. And also a website has a lot of really good educational materials. So feel free to dig around there. I see Jacqueline's got a question about the broker portal. If you need to be signed into the website, so go into lirealtor.com, make sure you're signed in. And once you're signed in, if you're a broker or an office manager, you should see the portal under resources for pros. It is maybe the third or fourth option that comes in under there. If you're not seeing it, just call the customer service department. They'll make sure that if you are a broker and office manager, I think they can help you make sure that you get access to it. But it's on lirealtor.com under resources for pros. And again, you have to be signed in because I think the ability to see it is tied to your status as either a broker or an office manager. All right, so another benefit that I just want to make you all aware of, if you're not already, we have a legal support center here at LIBOR now. This is in addition to the NYSAR legal helpline. It's accessible Monday through Friday. It is closed this week. The attorney who handles it is not in this week. So this week you would have to use the NYSAR legal helpline, but it's been a great success. I know a lot of members have used it. Provides you access to an attorney, not for legal advice, but certainly for information purposes. Give you information about existence of laws, different rules, can answer general questions. Free benefit to LIBOR members. It's available extension 335 at LIBOR. So you call the main number, 631-661-4800, and it's extension 335. So I want to kind of open things up with just to go over some questions that have recently come into the Legal Support Center. Another good benefit to having our own Legal Support Center is we as staff get to learn what's troubling you. What are the questions that you out there in the field keep asking? That helps us provide, I think, the best education to all of you. I went over this one at last month's legal update, but it actually came up again. I guess somebody missed the legal tip that we put out on it, or actually, I think OneKey put out a customer service tip on it, but this has come up 2 or 3 times in the last 2 months. So should square footage of a listing of basement square footage be included in the listing on the MLS? So you would look at MLS Rule 306.1. It requires you to put the approximate interior square footage when publicly available. The answer is generally basements shouldn't be included unless the basement is a legal space as per the certificate of occupancy. So if it is, let's say, a legal walkout basement, something like that, you've got certificate of occupancy, legalized space, then it should be included in the approximate square footage. Otherwise, it would not be. Another question that's come up, I know some of you handle commercial transactions regularly, some of you occasionally. Questions come up, well, are there differences? What disclosures do I need to provide on a commercial transaction? Well, this is sort of an odd one. You wouldn't think of it because it's the New York State Housing and Anti-Discrimination Disclosure Form. It still must be provided in commercial transactions. Even though it's a housing and anti-discrimination disclosure form, you have to provide that disclosure form to all parties at first substantive contact for all real property. It includes commercial. Oops, those came up reverse. Sorry about that. The agency disclosure form is not specifically required. That's that standard form from New York State. But you do, in a commercial transaction, have to disclose who you are representing, who you are, the agent for. So although a written disclosure is not required and you don't have to use the agency disclosure form, certainly nothing wrong with doing it. I would recommend that you really treat it the same way. You want to document that you did disclose the agency relationship. So there is nothing wrong with using the New York State agency disclosure form for that purpose. It's just not required. The only one that technically is required is the housing and anti-discrimination disclosure form. Let me see the question about whether there are guidelines to selling businesses via LIBOR, what disclosures or agreements. Not quite sure about that question. I'll take that one afterwards. LIBOR itself doesn't put out any rules when it comes to things like that. So we don't require any particular form listing agreements be used. Certainly to list a property on the MLS, you are required to have a listing agreement with the owner, but OneKey and LIBOR don't require any particular form listing agreement. LIBOR has an exclusive right to sell agreement that we put out for our members, both a residential and a commercial, but neither is required. It's really up to you. You should speak to your broker about what form they would like you to use for that purpose. All right, another question that's come up. Let's say I have a buyer prospect, they refuse to sign a written buyer agreement, and they also refuse to sign the agency disclosure agreement. What do I do? So, this has come up a little bit more often because now we are required, right? Before we tour a home with a buyer, you have to have a written buyer agreement under the NAR settlement. Um, if a buyer won't sign any agreement with you and we'll go over what the requirements are under the NAR settlement, but if the buyer won't sign a written buyer agreement, you can't tour a home with them. That is a requirement under the settlement agreement. In order to remain a released party under that settlement agreement, you have to follow that rule. So you absolutely, before you tour a home with a buyer, you must have a written buyer agreement. What about that agency disclosure form? So let's say the buyer says, all right, well, I'll sign the written buyer agreement, but I won't sign an agency disclosure form. You can still work with someone if they won't sign an agency disclosure form, but you do have to set forth under oath or an affirmation, a written declaration of the fact saying, I presented the agency disclosure form to the person, that they refused to sign it. Here were the circumstances, and you have to maintain a copy of that declaration for no less than 3 years. Believe me, Department of State will ask for this. If you're audited on a file and they ask for your agency disclosure and you don't have it, they will say, well, we want the declaration showing that you presented the agency disclosure form. So you do need to do this if somebody refuses to sign the agency disclosure. We've created a form declaration you can use for that purpose, and it's available on the Documents on Demand. Another question that comes up a lot, this one, maybe we get these service animals, assistance animal questions come up regularly. I think we had one question come up this month about, my landlord wants to, this is really more in terms of a pet. They'll say, well, I've heard questions about pets. Can landlords charge more to keep a pet in an apartment? Can they charge more rent? Yes, a landlord can charge a higher monthly rent for a pet. So they can charge pet rent. So if they want to charge 30, 40, 50, whatever it is to keep a pet. However, remember, this pet rent can't be charged to tenants with service or emotional support animals. If you've taken a course with me before, you've heard, and this is my cardinal rule when it comes to service and emotional support animals. They're not pets, right? I see a bunch of you who have glasses on right now. Think of service and emotional support animals as glasses. They are tools to assist someone. You might have a visual disability. You wear your glasses as a tool to assist you. There are individuals who have disabilities that use service and emotional support animals to assist them with that disability, right? So a landlord can't charge or put up anything extra, charge any impediment, or do anything to prevent someone from having a service or emotional support animal. As far as pets, yeah, they can have rules. Those are fine. So that is something that a landlord can ask or require, but they can't apply to a service or emotional support animal. Another question that's come up a couple of times in the last few months are, can I share another broker's listing on my social media account? Broker A on their Facebook page put their listing. Can't I just share that listing out to everybody else? No, you can't share listings of property that aren't yours without the listing broker's permission. So just because someone else placed their listing on social media or even photos of their listing on social media doesn't mean you have permission to share it. So I say photos too. I've seen instances where you represent the buyer, right? And you want to promote that you close the deal for the buyer, and you copy the listing broker's photo and create a post saying, hey, I represented Jane and John in the purchase of 123 Main Street. You can't do that. The listing, the photos, they belong to the listing broker. Unless you have the listing broker's permission, and I would say in writing, you should not share their listing, share their photos, anything. You need the listing broker's permission. The listing broker owns the listing. The listing broker owns the photos. You do not have permission to share their listing unless they have given it to you. Just by a broker Putting it out on social media does not give you license as another broker to use that information to share that listing out to your friends, followers, whatever. So just a word of caution there, because that could be considered a violation of the advertising regulations. It could be considered a violation of the code of ethics. All right. First topic I really want to dive into today is clear cooperation and some changes that you may have heard about in the last few weeks. This is a relatively new topic. So first, for those of you that aren't aware, what is clear cooperation? It's an MLS rule. This is the rule in the OneKey MLS that says within 1 business day of marketing a property to the public. So if you advertise a listing on social media, you put a yard sign out, any kind of public advertising, you, the listing broker, have to submit the listing to the MLS for cooperation. Defines what public marketing is. It's really anything, flyers, yard signs, you put it on the internet, social media. You do anything like that with a listing, within 1 business day of doing that, you have to submit the listing to the MLS for cooperation with other participants. This is an existing rule. This rule is not going anywhere. It has not changed. It remains in effect. The only changes to clear cooperation is NAR clarified that broker-to-broker communication is not considered public marketing. So let's say I have an exclusive listing, right? Exclusive right to sell. I have not put it on the internet. I have not publicly marketed it, but I call up another broker and say, hey, just got this new listing, wanted to let you know about it. That is not considered public marketing. If I engaged in that activity, I would not yet have to submit it to the MLS. But anything more than that, email blasts out to multiple people, things of that nature, that would be considered public marketing. You would have to submit the listing to the MLS at that point. The other thing that was announced, and this hasn't gone into effect yet in our MLS, but NAR announced a new MLS policy called multiple listing options for sellers, that gives sellers an additional option for marketing their property, or more flexibility to market their property. NAR approved this new policy just last month in March, but it hasn't been rolled out yet at our local level. It will be at some point. OneKey right now is reviewing the policy. They're going to provide an update on how it's going to be implemented, but it's not available yet. So what is this new property? I already confirmed this about the one-to-one. So what is this new multiple listing options for seller policy? Let me explain this. So sellers will be able to opt for, it's really almost like a new status. I don't know how, again, it's going to be rolled out in the MLS, but sellers will have an option for something called delayed marketing exempt listing. It will allow them to delay public marketing through the IDX and syndication while still making the listing available to participants. So seller could say, look, I don't want my property broadly displayed on IDX feeds, and I don't want it publicly shown on the OneKey site. I want some layer of privacy. That would be allowed, but the listing still gets submitted to the MLS, and other cooperating brokers would still be able to see it. They still would be able to show it. Not clear yet on what this delayed marketing period or delayed marketing exempt listing status period will be. Our MLS OneKey is, I think, in the process of reviewing that, and will ultimately make a decision on what the length of that period can be. If a seller is going to opt for this, they'll have to sign a disclosure. And same thing if they want to do an office exclusive, meaning that it won't be publicly marketed at all and not submitted to the MLS, they're going to have to sign a disclosure. So who has the ability to decide this? It's the seller, the seller's option. The seller has to authorize the listing broker to do this. Catherine had a question. What's the benefit to delayed marketing? I think it's an option for sellers who may want some level of privacy. They may not want their property shown on some of the portals and other IDX feeds. They may not want, curious people who don't have a broker to be eyeballing their property. Could be, I know examples have been given, a judge, someone in law enforcement, maybe somebody who has some notoriety that just doesn't want a large public display of their property. This gives them an option to have the listing submitted to the MLS to other brokers. Other brokers can see it and make it available for showing, but the public generally wouldn't be able to see it in other areas. So listing agents who represent sellers who choose to delay this public marketing, they're going to have a signed disclosure from the seller, their informed consent, saying they're waiving the benefits of immediate public marketing through IDX and syndication. And this disclosure is going to be required for both delayed marketing exempt listings and office exclusive exempt listings. It is a little different than coming soon. Coming soon listings are not available. Somebody asked a question, how is this listing different than coming soon? Coming soon can't be shown, right? So coming soon is you're making it available, you're showing it on the MLS as it is coming soon, but it's not available to be shown. This delayed marketing exempt listing it is available for showing. And it has to be made available for showing by other brokers. It just won't show up again in the public portion of the MLS, either on the OneKey public-facing website through syndication or on IDX feeds. So the listing is available. It can be shown. It's just not, I'll say, as widely publicly available. Yes, so somebody asked, does this mean the listing can be shown? Yes, I'm going to get into that, but yes, it can be shown. But again, if you're going to have, or your seller wants to opt this, they're going to have to sign a disclosure. And just I've said it once, I've said it twice maybe, but a third time, this is not in effect yet in our market. So this option for this delayed marketing exempt listing, it hasn't been rolled out yet. I'm sure before OneKey rolls it out, they're going to give you ample notice. They're going to give you a, explanation, more courses on this. I'm just giving you a really quick primer. We will work with OneKey to give you a lot more information. You won't be kind of blindsided by this. You will have plenty of time. Claire, so the rule will be similar to exclusive. It's similar in that, yes, you have to get the seller's informed consent and have them sign this disclosure. But remember, an exclusive means it can't be marketed at all publicly. So you're going to have, it's kind of an in-between. So you have the office exclusive, which means that no public marketing at all. It can only be marketed within the listing broker's office, or the listing broker has the option to call other brokers one-to-one and let them know about it. Any type of public marketing beyond that has to be submitted to the MLS. Seller has the option if they want. And again, I don't think this is something that the listing broker is necessarily gonna make promote to every seller. I would think in most instances, the seller is going to want to have full public marketing of the property. But if the seller, for some reason, says that they've got concerns about sort of full public marketing, they would have the option, as opposed to just a regular, what we have now, submission to the MLS, to submit it to the MLS, but without syndication and without it being made available on the IDX feed. But in either instance, whether it's an office exclusive or this delayed marketing exempt listing, you have to get the seller's informed consent. They'll have to sign off on a disclosure. OneKey will be developing, I'm sure, a disclosure form. And again, this will all be rolled out and with ample explanation once the rules and a date by which this will go into effect. So where can you learn more about this right now? You've probably heard this Facts.Realtor, and you're like, Patrick, you've said this before. NAR said it. Well, why do I need to go there? It's updated. All right. Facts.Realtor has a whole section just on this with a very detailed FAQ that will explain the policy in more detail, what it means, what you can do, what you can't do. Again, and then once we roll it out here in OneKey, you'll also get, I'm sure, much more information. But if you've got more questions in the interim, go to facts.realtor, check it out. And then, keep an eye on your inbox for more details from LIBOR or OneKey. We're trying to give you a little bit of this now, just so it doesn't kind of hit you all at once. I really don't think this is going to be a big change for most of you. It's just another option that will be available for sellers, right? So something, I don't think it's going to come into play on every listing. I don't think every seller is going to want to take advantage of this. I think it's just an option that you will be able to make available to your seller. And you would have to get them to sign that additional disclosure and explain to them what they're giving up if they want to go forward with it. So hopefully that gave you, I'm happy that I saw a couple other questions. I tried as much as I could to answer them. At the end, I'll stick around if there are more questions about this and we can discuss them later. I want to just give a brief, and I'm going to keep this brief. I know the NAR settlement is now in effect, right? We've all, I think, adjusted for the most part to the practice changes. But I just want to kind of go over a few things that I think you should all keep your eye on and make sure that you're doing so that you avoid any liability going forward. And also to make sure that you're all getting the compensation that you believe you're entitled to or that you've agreed to with the parties. So first, are you in compliance with the settlement? Make sure you're using the most updated version of whatever forms you're using. If you're using LIBOR's forms, make sure you're using the ones that we released we've updated in January. Check with your broker. Make sure you have all the required language in your forms that, commission is, fully negotiable, not set by law. Make sure you're following the required practice changes. Mentioned one at the beginning, that you've got that written buyer agreement before you tour a home with a buyer. And then lastly, are you taking the proper steps to get compensated? I'll talk about that in a second. So forms, remember, you need a written agreement with a prospective buyer before you tour a home. And that agreement has to disclose the amount or rate of compensation you receive. It's got to be objectively ascertainable, and it has to state that you can't receive compensation in excess of what the buyer agreed to pay you from any other source. So you have to make sure before you use LIBOR's agreement, you use NYSAR's agreements, whatever broker, whatever agreements your broker has, but make sure you have a written buyer agreement that covers at a minimum these three things. Also, all of your forms, make sure they have a conspicuous statement that broker fees and commissions are fully negotiable and not set by law. If you do that, you've kind of met the requirements of the basic requirements of the settlement. So please just, because I know occasionally some of you, look, you may have you may be in this part-time, you may not have had a transaction in a while. So if those things, fall or apply to you, just make sure you're using the most updated forms and your forms comply with the settlement. If you're not sure, check with your broker. All right, this is the big one. I say watch the gap for those of you here on Long Island, right? We remember the law. I don't think it's as big a deal now, but there used to be the whole thing with the gap between the train and the platform, right? And you had to make sure that you stepped over the gap and you don't fall in. And so what gap am I talking about? You're like, Patrick, we're not talking about trains. Why are you mentioning the gap, right? The gap is that compensation's no longer on the MLS. That means a lot. Right? It doesn't just mean you don't know if the seller or the listing broker are offering compensation. The gap is that offer had been a binding contract. I think a lot of people don't understand that. That was the contract that got you paid as a cooperating broker, right? We took away the compensation field. They're gone. That took away the contract. There is no longer any contract out there in the MLS that says if I'm a cooperating broker, I have a right to get paid something if the listing broker or the seller has offered it. That's the gap. So you've got to fill that gap now. Don't fall in the middle and not have anything filling the gap, because if you do, you're not getting paid. right? So previously, when the offer was put on the MLS, it was binding. It gave the cooperating broker the right to compensation if they were the procuring cause. That's not there. So before August and the changes, you really didn't need to be concerned about whether there was a written agreement to document how much the buyer's agent was getting paid or whose responsibility it was. A lot of you just sent a commission statement to the closing attorney and said, hey, this is what I'm getting paid, done. Yeah, I see a couple of, yeah, that's all I did. You can't do that anymore. You've got to have something that fills that gap. Otherwise, there's no agreement. Otherwise, you're at risk of not getting paid. This is a big deal. Now that offers are no longer permitted on the MLS, an offer, let's say it's verbal over the phone, or it's not binding. You need something in writing to confirm your right as that buyer's agent to get paid, and also to protect your buyer. Because if your buyer's believing that the seller is compensating you as the buyer's agent, you've got to make sure that you've documented that somewhere. So, couple tips, right? If the buyer's offer includes the seller paying compensation to the buyer's agent, make that clear. You should have a standard deal sheet that includes a line for seller paid compensation. LIBOR's form, we have a memorandum of offer to purchase sell. That's the non-binding sales memo, but at a minimum, you've got to make sure that you've included that in the offer so that the seller knows, yes, I'm agreeing. This offer includes me as the seller out of proceeds paying the buyer's agent. So make sure, one, you've included it in the deal sheet, whatever, or your offer, right? Second, make sure that you've then documented that ultimate agreement. Let's say the seller accepts that offer. We've got to make sure that we've confirmed that somewhere in writing. LIBOR has a form, confirmation of seller's agreement to compensate buyer broker form. It's the seller's confirmation. Yes, I'm agreeing to pay the buyer's agent's compensation from the proceeds at closing. You want to make sure that you've got something from the seller. Again, you don't want to walk in, at closing and suddenly like the seller's like, oh, I never agreed to this. And the buyer's going to say, yeah, but I thought my offer included you paying the seller's compensation. But seller might say, yeah, I didn't agree to it. Where's the agreement? So don't put yourself in that box. You want to make sure that you've got something in writing. Please make sure the attorneys are made aware. So if your deal sheet, your term sheet, your memo of sale, whatever you're sending off to the attorneys, if it includes the seller compensating the buyer's agent or paying the buyer's agent compensation, make the attorneys aware. We've been doing a lot of education to make attorneys aware that this is now something, it's part of the transaction. It's no longer in the MLS. It's got to be documented somewhere. So, send them that memo of LIBOR's form. Whatever form you're using, make sure you're making the attorneys aware that this deal includes seller paying X or Y to buyer's agent from the proceeds. If the seller signed that confirmation of seller's agreement to compensate buyer's broker, make sure you get that to the attorneys. It doesn't just protect you as the buyer's agent, but it also protects your buyer. Because the last thing the buyer wants to be informed at the closing is, well, now you have to pay out of pocket to cover your buyer's agent's fee. Even though the seller had verbally agreed to pay it, we forgot to put it in the contract. We never got their written agreement. Don't be in that situation. If the seller's agreed to pay as part of the deal, document it. And really the place to document it is make sure that it's in the contract of sale. That's why I say inform the attorneys. You really need to inform the attorney that this is something that is part of the deal. So if the seller has accepted that offer and that offer includes seller paying that compensation, make the attorneys aware, make sure it's part of the contract of sale. Again, we've been educating the attorneys on this as much as possible. We put out a piece for you to share. It's on the website, on our website. Just if you work with any attorneys, just a one pager that lets them know about the changes and about that this is now something that may become a more standard term of the contract of sale. So protect yourself, protect your buyers, make sure that you've got compensation documented either in that confirmation document or in the contract of sale. Lastly, don't try any of the settlement workarounds. We've been kind of promoting this heavily that you're just asking to get in trouble. So a couple workarounds that you should definitely look to avoid and that could warrant you into getting in trouble is seller paid bonuses. Remember, whatever the buyer's agent has agreed to with the buyer, that's what the compensation, that's the maximum. You can't accept more than what you've agreed to with your buyer. Supplementing a showing or touring agreement for a property already shown with a buyer representation agreement, including ranges of compensation and buyer representation agreements. Trying to leave compensation blank or open-ended. Look, the compensation that you agree to with your buyer needs to be set up front for each property. You can do it property by property. Buyer representation agreement doesn't have to be any duration. It could be, one showing, 1 day, 1 week, 1 month, 6 months. But whatever you've agreed to with your buyer, that's the compensation. That's what you've agreed to. That's what you're set at. You can't leave it open-ended. The whole purpose, or one of the major purposes of this settlement, was to ensure that buyers had the say in what their agents were getting, period. They can ask the seller to cover it, but ultimately the buyer sets that number, and that number or percent or whatever it is should be and needs to be in that initial buyer representation agreement, period. Deborah's got a question. What responsibility does the listing agent have in getting this signed? I think you were asking about either the confirmation document or I think it's, yeah, okay, the confirmation document. I think certainly if the seller's agreed to it, it's beneficial to the seller. It avoids any question, any dispute, as to makes the transaction run more smoothly. If sellers agreed to pay compensation, then yeah, they can sign that agreement, or at the very least, it should and needs to be in that contract of sale. I think not putting it in, it's going to raise the risk of the deal having a major issue at closing, or possibly falling apart, or the buyer not then signing the contract at the end of the day, or the party spending more time, money, effort on their attorneys. Look, if the sellers agreed and it's explained to them that they're paying compensation as part of this particular deal, then it should be on both the listing broker and the buyer broker should have a vested interest in getting it documented that way. Certainly, if the seller is not agreeing to pay compensation, then yeah, the listing broker wouldn't want them to sign anything. But if the seller's accepted an offer that includes paying compensation to a buyer broker, I think at that point the listing broker should want to have it documented properly so that the transaction runs smoothly. Yeah, no, Deborah's right. It avoids conflicts moving forward. Showing rentals, I don't want to spend too much time on this. You're not required in the case of a rental to have a representation agreement. Recommended, certainly, but the NAR settlement does not require any kind of tenant representation agreement before you show a property. LIBOR does have a tenant representation agreement that you can use if you want to have one, but it's not required by the settlement. The settlement does not apply to rentals. It only applies to purchase and sale transactions. All right, I'm going to spin through this pretty quickly. We only have about 15 plus minutes. It is Fair Housing Month. I just want to go over a couple best practices for all of you when it comes to fair housing. I did a legal tip on this earlier this month. And I think the number one thing that I want to impress upon all of you when it comes to fair housing is this number 3, have a system. It is so important, not only for fair housing, but really everything you do. Have a system in place for interacting with customers, following up with prospects, returning phone calls, sending out your forms. Just have systems in place so that you do those things the same way every single time. Because a lot of you, I've taught fair housing classes, I've sat in fair housing classes, and the common response is, well, how do we practice fair housing? Everyone says, oh, we treat everyone equally. Great, yeah, that's right. But how do you do that, right? You can't just say it. You need to have a system to do that. Because even if you truly intend to treat everyone equally, and you believe you can treat everyone equally, unless you have a system to do it, there's going to be instances where you don't do it just unintentionally. And that's where that can lead to fair housing claims, that can lead to problems. So you need to have a system in place. And that's why having like office policies and procedures in place for how you do everything every step of the way, it solves the fair housing problem. Because if you have a system, you're always going to treat every person, regardless of where they come from, what they look like, what their background is. If they have a disability, they don't have a disability, you're going to treat them the same way every time. So number one, have a system in place. I can't stress that enough. Let consumers set boundaries. You never want to be involved in steering. Don't direct consumers to particular neighborhoods. Let them, if they say, well, I want a good neighborhood, let them define what good neighborhood is. Don't give them a list of neighborhoods. That's steering. That's going to lead you in trouble. The consumer directs that discussion. And if they try to direct you, you need to redirect them back. You want to always offer every client a variety of choices. Again, these procedures in place for everything. Every broker is required to have standard operating procedures, right? And those pertain to whether prospective buyers need to show identification, they need a pre-approval, why am I forgetting the last one? Pre-approval and an exclusive buyer representation agreement. So whether they have those three things, but you really should have procedures in place for more than that. Everything when it comes to, how quickly do you return phone calls? Everything, just that way there's a consistency and there's never a question that someone was given the same answer, treated the same way. So I can't stress enough the importance of having procedures in place. Make sure that you're giving all of the necessary forms and that you're explaining them to every single consumer that you deal with. The New York State Housing and Anti-Discrimination Disclosure Form. Remember, this has to be provided at first substantive contact to all consumers. Good thing, Department of State just recently, earlier this year, put it out in multiple languages. Agency disclosure forms also available in multiple languages, but the state put this out as well in multiple languages. Not only should you provide this form, but explain it. I think it's important. It sets the kind of the real backdrop by which you have to operate. It makes you look more professional, and it makes a prospect see that you really do take fair housing seriously. Already went over this about the declaration that if somebody won't sign it, it's just like the agency disclosure form. You have to have a declaration signed explaining that you provided it to them. Your housing and anti-discrimination notice, this has to be available at all open houses, displayed, needs to be displayed at your office, but it also must be on your website. I know a lot of broker websites, or actually all websites, not just brokers, salespersons, anybody that has a website that they use for real estate advertising has to have a link to this notice, no question. And that would include social media. If you're advertising on social media, have a link somewhere on your, on the header of your page that goes to all of the required notices, including this one. If you're a broker, what three things need to be on your website or links need to be on your website? 1, New York State Fair Housing Notice. 2, you need a link to that broker standard operating procedure that I just mentioned. And 3, there's a reasonable accommodation and modification notice that has to be given to all prospective tenants at first substantive contact, you need a link to this on your website. If you're like, Patrick, you're going too fast, this is just intended to be an overview. If you've got questions about this, go to our website, go to lirealtor.com, and you can just look at the legal tips. You could just type, website notices, the whole article that will explain where you can find each of these, how you need to link to them on your website. But please make sure that you've got these on your website. You will be fined by Department of State if they see that you don't. And you can be fined for each instance. So, you could be looking at thousands of dollars in fines if you don't have this on your corporate website or any other website that you might use. And make sure that it's, these links to these notices, that they're clear and conspicuous, that they're easy for the consumer to find. Shouldn't be a struggle. All right. I'm going to just quickly talk about lawful source of income, and reason being, this continues to be an area that we've seen a lot of undercover testing in here in New York. And unfortunately, the testing has shown that discrimination of this protected class is still an issue. I was just at the Division of Human Rights Fair Housing Seminar, and I would say almost 50% of what they focused on was lawful source of income. And their goal is not to punish the industry, punish brokers who don't get this right. Their goal is to educate, and they want to make sure that people who need housing have the opportunity for it. So that's really the issue, that a lot of people who have different lawful sources of income, including vouchers, are basically being frozen out of the opportunity to even see properties. And that's a problem. And that's why lawful source of income is a protected class. So what does that mean? Means that a housing provider can ask about income, right? There we go. They can ask you about income. They can ask you about documentation. They can say, I need to make sure this tenant has the ability to pay, but they can't weigh different sources or treat different sources of income differently. They have to treat them all the same and accept all lawful sources of income. So they can't say, well, I like Evan better because he's got a job at LIBOR versus Dawn, who she gets her income from Social Security or child support or a voucher. Landlords can't do that. They can't balance and say, I like one kind of income better. They've got to look at all sources equally. Lawful sources of income mean all of these things and more, really anything you could think of that is lawful. The big one that that most of the testing focuses on is vouchers or housing assistance. So Jacqueline asked, yeah, landlords can ask individuals about their income. They can ask about things like credit. They can ask about bank account balances. The problem becomes with vouchers, and I'll get into that. You can't apply those to individuals who have vouchers, because the point is they have the voucher because they don't have that income. They don't have the money in the bank, but the government is saying, we're going to back this person up. We're going to pay their rent. So if you look at all those other factors and then you start applying them to voucher holders, that's discrimination, because that's preventing that individual from having the opportunity to get an apartment. So these are just a couple of examples in the last year where brokers, apartment complexes have been fined significantly as a result of undercover testing. And again, I've talked to the people that do this testing. Their goal is not to just do this gotcha, like, oh, we want to catch people in the act. They're really trying to make sure that those people that have vouchers have the opportunity, that they're not frozen out, that they are able to see apartments, put in offers for apartments, and be accepted for apartments. So, these instances where, responders, whether it's brokers or apartment complexes, saying, oh, well, we don't participate in that, or we've reached our quota, or they don't return phone calls of voucher holders, that's all illegal. And it's been a big problem. New York City alone, over $2.2 million in fines and penalties against owners, brokers for lawful source of income violations. Any of these things constitute source of income discrimination. Not responding, saying you don't work with voucher holders, saying I'm not sure if the landlord will. If you as a broker take on a landlord client, you're obligated to follow the law, right? And that means that you have to, or the landlord has to, accept applications from those who have voucher holders. If you're working with a landlord who says they won't do it, then don't work with them anymore. You have an obligation to follow the law, and not discriminate against anybody based on their lawful source of income. So never turn away any prospects because they receive financial assistance. It's again, have a system. Follow standard procedures for all prospects, regardless of their source of income. So you should have a set of questions that you ask any prospective tenant. And it doesn't matter if they have a voucher, if they have Social Security, if they have a job, whatever. Same questions. What area are you looking in? How many bedrooms are you looking for? What's your price range? Not, oh, well, you have a voucher, so I can't show you an apartment. It's having the standard questions. That's the way to avoid any issue. And make sure everyone in your office knows this, right? You want to show voucher holders the same apartments you would anyone else. If somebody does have a voucher, just like if somebody had a job and the landlord wanted proof of their, like a W-2 statement, if somebody has a voucher, you want to get proof of the voucher, copy of the voucher, name of the caseworker. Get that information so that you can find out that the program would cover this particular apartment. I see a bunch of questions about this. I'll address them after because I just want to get to the last couple topics here. And that's just a couple of laws that I want to make you aware of. And these are, some are in effect, some may be going in effect. So we'll cover these in the last 5 minutes here. So the New York City Fair Chance for Housing Act, this is something that went in effect. It's in New York City only. And I will make these slides available. I know a couple people put that question in, so slides will be made available on the website under the legal update section under legal. So this went into effect January 1st. So it places limits on the type of background check that landlords can do for apartments. First, if they're going to do any kind of criminal background check, they need to provide a specific fair chance housing notice to the tenant. The scope of a background check is now limited. It's only can be to certain reviewable criminal history, and that's set forth here. Registered sex offenses, convictions for misdemeanors that are less than 3 years old, or for felonies that are less than 5 years old. And if something comes up on the background check, the landlord has to engage in a fair chance housing process. So it involves an individualized assessment where the landlord considers the nature of the conviction, gives the prospective tenant the opportunity to respond. And also the background check can only be done after the applicant's been approved and provided a copy of the lease. So it can't be a screening tool to say, well, I'm not sure if I want to offer this person a lease. It can only be done at like the last step after the lease has been presented. Then the landlord can do the background check. It needs to be limited. I would, if you're involved in this process at all, I would say certainly speak to your broker. Your broker should probably speak to their attorney. You should probably make sure that you're partnered up with background check service that is in compliance with all of this and understands the changes. This is New York City only right now. The state may have a different law coming out at some point, but if you're doing rentals in New York City, you need to make sure you understand this if you are involved at all in the background check process. Yes, Queens is part of this regulation. New York City includes Manhattan and the 5 boroughs. So this would include Queens as well. Short-term rental law. This just went into effect. All I'm going to say about this is the state has put a lot more regulation on short-term rentals. The definition of a short-term rental has been expanded. If you are going to be a booking service, which the law is not really clear. To me, if you're listing the property for somebody, a short-term rental, you may be considered a booking service. So hosts and booking services of short-term rental have to register their properties in a local registration system now, and they have to collect taxes. So if you're going to get involved in listing short-term rentals, be careful. Make sure you're following the law. I would highly encourage you to speak with your broker or your attorneys. I know some brokers have said, I'm not even going to get involved in short-term rentals anymore. It's just not worth the reward isn't worth the risk. But I guess my caution here is you see short-term rental, you're asked to do one as a listing broker. Make sure you stop, look at what's out there in terms of the guidance, and probably talk to an attorney to make sure that you're doing it the right way. Because it can be, if you violate the law, it can be grounds for discipline by Department of State. Last thing I want to cover, just the New York City Fair Act. This is not the Fair Chance Act. This is Fair, F-A-R-E. Fair Chance is F-A-I-R. But the Fair Act, which is the Fairness in Apartment Rental Expenses, this is scheduled to go in effect in June 11th. It's not in effect yet. There are challenges right now pending in the courts. NYSAR, our state association, REBNY, which is a trade association in Manhattan, and some others have filed a lawsuit challenging this law. So it's not in effect yet, but if it does go into effect, and this is the question, as agents allowed to charge tenants the broker fee? So this is the question Tyler just asked in the chat. If it goes into effect, it's already passed. So it's not a matter of if it has to pass. The mayor, this is New York City only, the mayor's approved it, the city council's approved it. Landlords in residential lease transactions cannot charge brokerage fees to the tenant. And so listing brokers for the landlord cannot collect a fee from the tenant. They can't advertise that they are asking the tenant to pay the landlord's broker fee. They can't collect a broker fee from the tenant if you're representing the landlord. So if this goes into effect, that practice will be prohibited. So you would need to make sure you're not advertising that the landlord is seeking the tenant to pay the broker fee. You wouldn't want your listing to advertise that. You would need to make sure that your listing agreement with the landlord doesn't say that the tenant's going to pay the fee, because that would be illegal. The tenant won't be allowed to pay the fee. Whatever compensation you as the listing broker are going to get would have to come from the landlord. So you'd want to document that in whatever exclusive right to rent agreement you had with the landlord. So yes, Mona Lisa says the landlord would pay the agent again. Laurel, good question. She asked, can the tenant's agent charge the tenant a fee? Yes. The tenant agent, if let's say you're working with a tenant, you've got a relationship, an agreement with a tenant to show them properties, you're a tenant's agent. This only applies to a landlord's agent being prohibited from collecting from the tenant. A tenant's agent could still, if there was a relationship, a tenant's agent could collect a fee from the tenant, provided that tenant's agent is not working for the landlord. So that would still be permitted. We will put out, we've put out some guidance on this. We're kind of waiting to see what happens with this lawsuit and whether things go into effect. So I would imagine in the next few weeks we will definitely be putting more information out there. Yes, we do have, Kyle has a comment. We do have a new exclusive right to represent tenant agreement that has been put out. So that would be used if you are representing the tenant. And also our exclusive right to rent agreement does not have any language in it whereby the tenant is agreeing to pay the landlord's agent. So that agreement would not need to be modified. But if you do have agreements like that, and this does go into effect, make sure that you are aware of it. But we will put more guidance out on this shortly. So just kind of giving you a heads up. I know it's a lot. I actually had a couple more things that if I could, I would get to. So I appreciate everybody's patience. Thank you. I think